Hey everyone, Chase Elleby and Joel Williams from Williams Elleby coming to you today with week number 49 in our video series of 52 weeks of personal injury. And today we're going to talk to you about how a child's settlement or claim is different from an adult's claim. So Joel, tell us just briefly what the difference between an adult claim and a child's claim in the state of Georgia is.
Yep, so this is specifically for the state of Georgia, no other state. So if you live in Montana, go watch somebody else's video because we're talking about Georgia today. But a minor does not have legal standing to bring their own claim, right? So it's got to be brought by somebody else on their behalf. Usually that's a parent or a guardian that's going to bring the claim on the minor child's behalf.
Right, exactly. So the minor child, they can have medical bills, they can have injuries, they can have pain and suffering, all that stuff, but the claim can't be brought by the minor, it has to be brought by the parent. Now, specifically in the state of Georgia, it's actually the parent who has the claim for the medical bills because the parent is the one who is legally responsible to care for the child and to pay for those medical bills. So in Georgia, if we have to file a lawsuit on behalf of a minor, it's going to be styled, as the parent and legal guardian of the minor, and specifically listed in the complaint is going to say that the parent has the claim for the medical bills, right? So if the child has to go to the emergency room and they have a $15,000 emergency room bill, it's not the child's claim because the parents are the ones that are, or the legal guardian is the ones that's going to be responsible for that charge.
Sometimes it's interesting too because you'll have a minor that maybe they're 17 at the time of the wreck, and so they're treating and they turn 18 years old while they're treating. Well, then you sort of have to split it up because the parents have the claim for the medical bills while they're still a minor, but once they become an adult, then it's the former minor's claim for the medical bills.
Right, and I think probably the most, I don't want to say confusing, but the part that takes the most attention with any minor claim is what happens after the case has been settled or after it's been resolved. On the front end of the case, it's really the only difference is the fact that the parents or the legal guardians are the one that are bringing the claim, and then the parents or the legal guardians are the one that have the right to the medical bills or can bring the claim for the medical bills. But on the back side of a minor settlement claim in the state of Georgia, it can get pretty ticky-tacky depending on the amount that the settlement is going to be on behalf of the minor, right? So just recently, the law changed to where it's now $25,000 is sort of the number that you have to think of, right? So if the case settles for less than $25,000, you don't have to have a conservator. The minor settlement doesn't have to be approved by the court. The parents can sign off on the settlement, and it's a lot easier. If the settlement amount is more than $25,000, but the net amount to the child is going to be less than $25,000, so meaning after taking out attorney's fees, if there's any liens or expenses or anything like that, if the net amount is less than $25,000, you have to get court approval, but you don't have to have the parent or legal guardian be appointed a conservator, which can take a lot of time and a lot of effort to get the conservatorship appointed. Now, if the case
and there's a lot of work on the back end once the conservator is appointed.
Correct, right. And then if this case settles for more than $25,000 and the child's going to net more than $25,000, then you have to get court settlement or court approval, and you have to get a conservator appointed. Now, there's certain ways to, I don't want to say get around it, but there's certain things you can do to structure a minor settlement, things like annuities or structured settlements that take out the conservator requirement, because it's basically going to fund an annuity. The child's never going to see it until they reach a certain age. For instance, if say you settle the case for $30,000, the net amount to the child's going to be $20,000. Well, you can put that in an annuity and say the child's 5 years old when the case settles, and you choose to have a lump sum when the child turns 18. Well, that $20,000 is going to grow tax-free. It's going to be paid out to the child tax-free when they turn 18. And if they've been, if that money was invested at 5 years old, it's going to be a pretty good chunk by the time they turn 18. And so there's certain options and certain companies out there in Georgia that will take that, or not, the companies don't take the money, they help set up the annuities, and it's usually like a life insurance company or things like that, that will fund the annuity and have payouts. And it can be a lump sum at 18, it could be once they turn 18, they can get a payment every 4 years or a payment every month. However you want to structure it, you can be pretty flexible in doing that.
Yeah. And like Chase said, the law just changed on that. In Georgia, it used to be $15,000. So if you've seen any other articles or any other videos that came out prior to what was it, May of this year, July of this year?
Right, of
Prior to
2022.
summer of 2022, and it says $15,000, that's no longer the case, it's now 25. But the main thing is that the courts and the laws in the state are trying to make sure that any money that a minor gets from a settlement is used solely for that minor's benefit,
Correct.
right? They don't want the parents going out and paying for, clothes for the kid, to wear to school, because
Right.
that's the parent's responsibility anyway. This money is supposed to be set aside for the child and for the child's use once they become an adult. There are certain things that the money can be spent on, but those are very specific on a case-by-case basis. So if you have a situation where your child's been injured, whether it's a daycare, a dog bite, a car wreck, a medical malpractice, or anything like that, there are additional procedural steps you have to take to make sure it's done correctly. And in those situations, I would be hard pressed to imagine someone with no legal training handling a minor child's case on their own. It's definitely worth getting an attorney. It doesn't matter if it's us or somebody else, but you need to reach out to an experienced personal injury attorney if your child's been injured and you need to bring a claim on their behalf, for sure.
Absolutely.
So, all right, well, I guess that wraps it up for 49, unless you've got some other pearls of wisdom to bestow upon us.
Plenty, but I think that's enough.
Okay, all right. Well, that'll wrap it up for week 49. We will be with you again next week for week number 50 out of our video series of 52 weeks of personal injury. We're nearing the end here, but if this video has been helpful, we'd appreciate you giving us a thumbs up, subscribing to our channel, and sharing it with your friends.